Welcome to the afternoon constitutional, and thanks to our sponsors, the Government Accountability and Oversight Group, govoversight.org. We've got a great program, but I want to begin with a story that a lot of my friends have been tweeting to me. As far as I can tell, and I only am in contact with him infrequently, George Soros is still very much alive and is I don't know where these rumors start, but I guess after you get to a certain age, people just say stuff because eventually it'll be true. It's the old spaghetti and the kitchen wall process of journalism. A story we had for you a couple of weeks ago, one of our earlier episodes about Eric and what Eric is and what Eric isn't, and how Eric has been manipulated by those in the Democratic Party to create a whole other category of voters that had not heretofore even been on the voter rolls and had used the system after convincing conservatives, yes, this will help us clean up the voter rolls. Well, it is gone from the Commonwealth of Virginia, and so you can rest easy, at least for now, that they can only go after the ones and twos, not the entirety of the cast of characters that they had been hoping to add there. But we begin this week's show, this Monday morning show, hoping you all had a wonderful Mother's Day. And I hope none of you, if you are in the doghouse this morning, it's because you made the classic mistake and said, she's not my mom. So you have 364 days to make right for your mistake. I tried to warn you. I tried to say that mom is a transcendent title. If she's the mother of your kids, she's still a mom and you must represent. But joining us to talk a seminal victory in court for free speech and the First Amendment out of the state of Arizona is Jacob Huebert, who is the president of the Liberty Justice Center, and he joins us to tell us a little bit about the Arizona versus now. And I don't want to mispronounce the gentleman's name, but I believe it is pronounced Tizon. Jacob, welcome to the afternoon constitutional. I guess his camera not on yet, but Jacob, welcome to the show, and thank you for taking some time out to talk with us about the state of Arizona versus Tizon. Catch us up on the radical documents that this young fellow was handing out at Arizona State University. How are you today?
Great, thank you, and thanks very much for having me. This student at Arizona State University, Tim Tizon, was handing out copies of the U.S. Constitution, and in a main area of the campus where lots of people are passing by. Wasn't in anybody's way, wasn't obstructing traffic, just giving copies of the Constitution to people who were interested on behalf of his students, a group, Young Americans for Liberty.
Heard of him?
And
Yep.
as he was doing this, he got approached by campus police who said, "Where's your permit for doing this?" And he said he didn't have one, and they arrested him. And he ended up being charged with criminal trespass, and he ended up being convicted of criminal trespass for handing out copies of the U.S. Constitution on his own college campus in a public space.
Oh, so arrested on his own college campus. That's the part that really surprises me in this, and how brazen that they are about this, Jacob. So was and understand this was the U.S. Constitution he was handing out. This wasn't some radical flyer from the alt right or anything like that. This is we the people in order to form a more perfect union, that kind of thing. What was their premise? What did they tell him he was being charged with?
Well, ultimately, they said he was being charged with trespass because he was where he wasn't supposed to be, which of course doesn't make sense because it was a public space where anybody could be. But they said, no, if you want to hand out literature here, you need to get a reservation in advance. You need to apply for that. You need to do it a week in advance, and then we'll process that and let you know if you can exercise your right to free speech there. But of course, that's not how our constitutional rights are supposed to work. The whole point of the right is that you get to just go do the thing. You don't have to ask for somebody's permission. You don't have to jump through hoops, especially when it's as simple as this: when you're in a public space where you have every right to be and you're not in anybody's way, and you're giving out, of all things, the US Constitution. Of course, it shouldn't matter what the thing said, but you'd think if you could hand out anything under your First Amendment rights, it would be the Constitution itself. But no, he was arrested and convicted. But fortunately, once he was convicted, we were able to step him and help him assert his First Amendment rights in court.
Well, it talk to that part of it because we warned about this when they began the process of coming up with these what they called free speech zones, where under the auspices of protecting somebody's free speech, they were going to set up a system where you had to go plead with the bureaucracy and put in a permit and then get the permit or not, and then you had to fit within very tight guidelines of what it was you were going to be speaking about. So and aside from an "I told you so" moment that he arrested this kid, talk about the process being the punishment, because I think his arrest probably has a greater impact on the people who might have, oh, I don't know, read the U.S. Constitution and said, oh, I better not do that because I might not be able to handle the legal fees.
Well, that's right. I mean, there's a couple ways the process is a deterrent. First, having to just go register and do all that stuff is going to discourage people from exercising their rights because you're imposing a cost on exercising your rights that shouldn't be there. And then, of course, the possibility that you could be arrested if you go about exercising your rights is going to chill people. It's going to make them less inclined to do any of this at all, to stay out of trouble. And that's why it's so important that he chose to fight back and that we were able to fight back on his behalf. Once we went to court, we made the argument that this clearly violates the First Amendment, also violates Arizona law, which is designed to protect public spaces on college campuses. Arizona specifically wanted to protect students' right to do this sort of thing, and they disregarded it. And once we got into court and made that argument for him, the state actually gave up. Instead, they didn't even make an argument trying to justify this. They filed something saying, oh, it turns out the factual record wasn't developed well enough. So we're not admitting we did anything wrong here. We're not admitting we violated his rights, but we'll go ahead and dismiss this case. We'll drop the charges. And so he fortunately will not have a criminal record now, which he otherwise would have had, and won't be in trouble for having done this. But you're absolutely right that this could still chill other students who don't want to have to get lawyers and go to court and temporarily at least have a criminal record. And that's why it's important that we follow up on this and that we go back and we make the school now, we challenge this whole policy and make the school do the right thing going forward, have a court tell them that they have to do the right thing going forward. That may be why they didn't want a court decision in this case, why they didn't defend themselves, right? Because then you get a court decision telling them that they can't do this. Well, they're not going to get off the hook that easy. We're going to make sure they're held accountable.
Well, Jacob, president of the Liberty Justice Center, you guys stepped in and helped this young man out. But what would it have cost somebody to hire a lawyer? Even a young up and coming one. These billable hours must have, I'm sure you have an accounting somewhere. What would it have cost somebody to just privately hire an attorney to fight the amassed numbers of the state's attorney general office to defend themselves in a case like this?
Well, it would have cost presumably thousands of dollars. Attorneys probably, even a sort of ordinary attorney would charge, I would expect, at least $200 an hour. And so once you spend even 5 hours on this, you're at $1,000. But it's going to be more than 5 hours because they've got to make sure they get the law right. They've got to go to all your hearings. They've got to write the briefs. So you're looking at thousands of dollars at a minimum to protect your rights here. And of course, few students can afford an extra few $1,000s just to be allowed to exercise their rights. Fortunately, we represent all of our
Mhm.
clients free of charge, which is why he was able to get legal representation in this case.
Well, and that's why, of course, anyone who's watching us should go to libertyjusticecenter.org, help these folks out, and do what they do for people like this young man. You mentioned the policy. Now, the next phase is to press the policy, to push the policy issue on the university. There are an awful lot of universities that have these free speech zone sorts of policies. Is this sort of a precedential thing, Jacob, or in your mind, that could bring down all of these dominoes across all these universities under the phony baloney guise of protecting free speech when doing just the opposite?
Well, of course, when we bring lawsuits, we always want to set a precedent that will help not only our client, but everybody else in a similar situation. Now, this case, because the government went about it the way it did, we don't get a court decision to set a precedent. But if we go back and we sue and we challenge this and we do get that court decision, then that will be a useful precedent. Of course, how widely it applies depends on how high the case goes. You get to the US Supreme Court, you get the entire country. If
Hmm.
you win at the lowest level and it stops, maybe it's just technically just in Arizona, but it helps everywhere because now everybody has something to cite. And again, it will be especially good because Arizona passed a law to stop this sort of thing. So we just need a court to say, no, this law means what it says. You have to follow it. And if you don't follow it, you're going to be held accountable in court. And hopefully that'll make all of these universities in Arizona, and we would hope elsewhere, get in line.
Well, and we had warned as this concept started to bubble up years ago, Jacob. It seems, sometimes my mind gets full of these news stories, so it's tough to tell, but it could be almost a decade ago when these universities started coming up with free speech zones, and they would tell everyone, oh, this is so that nobody is silenced, but we're going to, and in some cases they left it up to administration staff. Sometimes they left it up to student governance bodies, and it was notoriously hard for groups like Young Americans for Freedom or Turning Point USA to get time in these free speech zones to make that case. And we said it from the highest mountain from the get go, and I'm sure you did as well at the Liberty Justice Center. Uh, but yet they maintain them. They get stronger and stronger every day, especially under this guise of diversity, equity, and inclusion. Is this what makes this particular case a building block to fight that?
Yeah, absolutely. We need to get more, the more court decisions we can get on this, the better. From whether it's state courts, federal courts, we need to have a body of law that makes this clear. Now, really, it should already be clear. The First Amendment's been around a long
Yeah,
time.
you think?
The case law on what you can and can't do in a university has been around a long time. But obviously, we can't take that for granted. We need to freshen this. We need new decisions that cement this even better in the law. And that's a big part of why we bring these cases, to make sure those precedents are there and are fresh and are going to be followed.
So you've taken up several other controversial issues, Jacob, at the Liberty Justice Center, and specifically the schools and the masking policies. I saw one of the most eloquent treaties was written in Virginia by a Democrat member of our Senate, which I think was a real stunning defeat for the authoritarians. Talk about where you are in some of the battles you have regarding mask mandates, even as we get past the COVID-19 emergency in Washington, Jacob.
Well, one of the most outrageous mask mandates we've fought against successfully is the mandate that the federal government, the Biden administration, imposed on Head Start programs, where they not only forced teachers to get vaccinated and to wear masks, but they also forced 3-year-olds who are in these programs to wear masks when they're in school, even if every other kid in that same school doesn't have to wear a mask. And how outrageous is that? The low income students are going to wear this sort of mark on their face
Hmm.
that singles them out, and they're going to be subject to this outrageous rule that
Right.
nobody else
Yeah.
is subject to.
Right.
Fortunately, as with so many of the Biden administration's orders, the courts have found this to be unlawful. They had no authority to impose that kind of
Yeah.
mandate. And we were fortunate the federal court said that late last year. We're in front of the Federal Court of Appeals that we're pretty confident will say the same thing. Of course, now that they're approaching that point, they're like, oh, never mind. We're gonna terminate
Hmm.
these things. Nothing to see here, courts. But we're urging the courts to keep ruling on these things as and we have cases on that in different parts of the country. And we're going to urge the courts to hear this because, of course, what they stop doing at one point, they could always start doing again. Oh, COVID
Sure.
conditions have changed. Now we need this again. So we need court decisions to make clear that they don't have the authority to impose this sort of thing.
Well, and that was why I kind of went into this story. There's a personal reason. Yeah, there's a third story that I noted from your website that you're involved in, but I'll get to that in a moment. Because I brought this up because we're still in my business very concerned about what comes next. What is the next public health emergency? Whether it's they've already telegraphed gun violence, the global climate change, any number of things, but those two seem to be the leader in the clubhouse for the next health emergency that the president or a future administration might use for those sorts of things. So I want to collect these precedential rulings, even if the Biden administration says, "Oh yeah, you know what, we were a little caught up in it. You know, we were just a little, you know, everyone was crazy," because I think that we're going to need these arrows in the quiver come the next existential health emergency. Do you disagree or agree, Jacob?
Well, of course, I agree that we need these precedents in place to stop them from doing this again. Now, of course, when they pose a mask mandate, say they have to point to some federal law that they claim lets them do this, and so they do. And that law, of course, says nothing that would suggest that they can impose a mask mandate. And so, but then the issue in that case becomes, well, did this law let them do this? And the courts have to look at that and say whether it does. And they've consistently said no in this particular case. But
Hmm.
and so when the next thing rolls around, maybe they'll cite some other, they'll point to some other law,
Right.
and we'll have to argue about that. But what's important is that we have courts who are actually willing to hold them to the text of the law. And so when you do have that decision where the court's saying, no, you can't stretch words in this way to do whatever you want. You can't say there's an emergency and that means that words now mean something different
Yeah.
than they meant in the past. Those precedents are going to be extremely valuable. And it's why we've just kept on fighting this, even as the restrictions have lifted in so many ways. It's really important to fight all of these things to the end.
Now, Jacob, I'm going to apologize in advance. This episode may disappear from YouTube very quickly because we've only been on the air for a few weeks using our YouTube channel, and I've already had one episode taken down because I was discussing a certain airborne virus and treatments for it with one of the doctors that was doing treatments for it. Now, you guys, and I'm speaking again for the YouTube algorithms, this is strictly a legal conversation about free speech and some doctors in California. Jacob, tell us about the case of these doctors who, like this program, have had their speech at very least muzzled or removed.
Yeah, last fall, California passed a law that says that if doctors give their patients misinformation about COVID, then they could be disciplined by the state or even have their licenses revoked. So the question, well, what is
Unbelievable.
misinformation? Well, misinformation, according to this law, is anything that goes against the scientific consensus. Well, what's that? Well, the
Yeah.
law doesn't say. And of course, the whole concept doesn't make much sense because science is just a process of questioning things and
Hmm.
figuring things out. And ideas about medicine and science are constantly changing as a result. There is no official consensus. And we know that that concept makes no sense, not only from the very definition of science, but from what's gone on with our clients. We represent two doctors in California who early on in the days of the pandemic were saying certain things. And to help you out with YouTube, I won't get into too much detail, but things about masks and things about what vaccines might and might not do and
Hmm.
all that sort of thing that were very controversial at the time against the official consensus, what government
Yep.
officials were saying, and about the efficacy of certain treatments. And all those things would have presumably got them in trouble at the time, but their positions on many of those things, if not all of them, have now been proven to be right. And now everybody or most everybody agrees with them on a lot of what they're saying.
Sure.
And
Yeah.
so now they have to wonder, well, what am I saying now that is against whatever the consensus is now, or will be against the
Well,
consensus? In the future.
Well, and isn't that you mentioned science in general, and the idea of a scientific consensus, is chilling because there were times when the scientific consensus where the color of your skin indicated who was more intellectually prowessed or not, or that just letting out some of your blood would cure you of the diseases that were running through your blood. So scientific consensus, the world is flat, for example, is almost an oxymoron, isn't it, Jacob? Just in and of itself.
Yeah, of course. It makes no sense because it's an ongoing process. And the way you do science is by questioning things, by talking about things, to test your ideas, to see if what you thought yesterday is actually correct. And to freeze that in time as a consensus is anti-science. It makes no sense whatsoever. And of course, the whole thing is also contrary to the notion of the doctor-patient relationship, where the
Hmm.
doctor is supposed to get the best information they can and make the best judgment they can, and then give the patient their best, honest advice. And when you impose a law like this, they can't do that. The state is getting in between the doctor and the patient, and it
Hmm.
not only hurts the doctor, who has First Amendment rights to say
Yep.
whatever they want, it also, of course, hurts patients because it deprives them of information. And patients uh, can get second opinions. They
Sure.
can hear different opinions too and decide what they think is the best course of treatment for them. But California just wants to shut all this down and
Of
shut
course.
doctors up. And it's very chilling because it's COVID in California today, but who knows what else it will be in the future
Hmm.
in California and in other states that pick up this concept.
Right.
It's a really outrageous violation of First Amendment rights and medical freedom.
Well, and you mentioned what could be next. Again, circle back to climate change being one of those things that have been mentioned in the same sentence as public health emergency. And we've seen attorneys general offices get co-opted by Bloomberg Group attorneys to go after people that would give money to scientists who question the dogma of climate change. So I can see the scenario playing out already in this. So we need to, again, get these arrows in the quiver for you. Where does that case stand?
That case is going to be argued at the U.S. Court of Appeals for the Ninth Circuit in July. The lower court in that case ruled against us. I can't even tell you why, and as much as it just doesn't make any sense at all, because this is obviously a straightforward violation of First Amendment rights. But we're going to go to the Court of Appeals, and we'll go as high as we need to go to protect doctors' First Amendment rights.
Well, isn't it a scary place, Jacob? And I don't know how long you've been practicing law. I presume by being president of the Liberty Justice Center, it isn't, 3 weeks of Sundays interning at a law firm. That judges can make rulings not based on the law, but because it's scary. Because people are scared and we have to rule these ways. I mean, this is anathema to everything, to all the canons as I understand them, is that just because it's scary doesn't shouldn't suffice as legal grounds for a decision.
Well, you're absolutely right. And I think that's a reason why, when all these restrictions started back in 2020, uh, people would go to court and challenge these things, challenges exercises of governor's power and that sort of thing that obviously went outside of their legitimate powers, but courts just weren't willing to do anything about it because the judge doesn't want to be the guy who stopped something that, well, maybe it's going to save lives. We don't know. They don't want to be that person. They don't want to be responsible. And so they pass the buck to to other officials and don't intervene as they are obligated to do as a part of their constitutional duty. I think that's also a reason why some people, some organizations that would normally stand up for freedom didn't rush to court on some of these things, because there's the risk, well, these judges are going to be afraid, and because of their fear, they're going to set a really bad precedent. Fortunately, judges have done better, a lot better more recently, and those precedents will stay on the books. And hopefully next time there'll be a lot more courage all around to stand up to these things, now that people realize how much harm was done this last time around.
On Friday's program, we were visiting with John Whitehead of the Rutherford Institute based here in Charlottesville, and he was talking about how few people understand the Bill of Rights. And he had an intern from the University of Virginia Law School who said her professor said straight out, we're not studying the Bill of Rights in this class. And she came to intern with him simply so that she could work in this world of the Bill of Rights and the subsequent amendments to the Constitution. What does it say about a world where one of the preeminent, and I'm told in the legal profession, still considered to be conservative law schools, doesn't even talk about the First Amendment anymore?
Yeah, it's a scary time when, the government has never respected First Amendment rights perfectly, or there's always been problems. We've always had to fight very hard to preserve our First Amendment rights. But it's not until recently, at least in our lifetimes, that you see people coming out explicitly against the concept of free speech, explicitly saying that, well, free speech works against other values that are very important to us. We should downplay that. You should be suspicious of the people who care so much about free speech. That really feels like a new thing that's come up in recent years, and it's super disturbing. It's very extremely disturbing to think that people in law schools who are being taught that attitude are going to be our judges in 15, 20 years. So that's why it's just so important to set the best precedents we can now, and to do everything we can to educate the public, law students, about the rights that we're all supposed to enjoy and why they're important.
Jacob Huebert is the president of the Liberty Justice Center. Jacob, thank you so much for taking some time out with us. Congratulations on it's Tizon, you said?
Tizon.
Tizon. On the Tizon ruling. Good luck in California with that ruling as well. We'll be watching, and we'll talk to you again very soon.
All right. Sounds great. Thanks so much for having me.
Not at all. Not at all. Jacob Huebert, president of the Liberty Justice Center, libertyjusticecenter.org. Thank you for joining us this week. And next episode, tomorrow, we're going to have Ben Knotts from Americans for Prosperity, as well as Hayden Ludwig, who's dug into the ERIC programs as well. So until that time, so long, and thanks for all the fish.